A child custody order can be modified after a divorce, but don't count on it. Custody modifications are very difficult. And I always say, look, you want a surefire way to break your heart and empty your pocketbook, file a custody modification. Because courts want stability for the kids. They want these orders that they take the time to enter to last for a child over the duration of their childhood. So the child knows what to expect and parents don't keep dragging their kids back into court. So you definitely don't want to enter orders now thinking that someday you can get them changed. Because, though that's technically possible, it's really hard to do. To get a custody modification across the finish line in the state of Texas, you need to prove that there has been a material and substantial change since the entry of the prior order. I'm like, Hannah, what does that mean? It just means you got to prove some big deal happened since the last time an order was entered. And not big deal in just your mind, like this person continued to be a butthead. That is probably not going to get you there. Think in terms of what impacts the core of your child's development and safety. Like, for instance, some things that may get you to a material and substantial change. Becomes clear as a child ages, they need to get on ADHD medication. That's the recommendation of their pediatrician, followed up by the recommendation of a psychiatrist. And one parent refuses to let that child get on medication. Remember, we've talked a lot about the joint managing conservatorship and the rights that normally parents share, which gives one parent a veto power. So they say, no ADHD medication, boop, effectively vetoing it. And this parent saying, wait a minute, I need to follow the advice of the expert. So their options are to not let their child get on the medicine because this parent won't agree, or to go back to court and say, hey, court, I need some help here. My child is going to suffer or is suffering if things are left alone. It will really impact their psychological and maybe even emotional, physical well-being if they don't get on this medication. Please help. That's a circumstance where you might want to bring a custody modification with some chance of success. Courts really don't want parents continuing to drag their families and their children through the court system. So they're going to lean towards telling you, no, leave things as they are so your kids have stability. That all being the case, I've been a part of 2 custody modifications. And sometimes things are worth fighting for, and you have to. You really need to go over this with a lawyer. And I do want to give you this advice. With that lawyer, I want you to tell them to tell you the truth, to level with you and be straight with you, because you don't want them just telling you what you want to hear. And before you know it, you're going to find yourself $100,000 in legal fees, 6-8 months down the line, and still left with no change. That very much could happen to you, and it's a risk you need to weigh against the potential benefits with a lawyer who really cares about making sure that you only do what's absolutely necessary to take care of your kids. That's what we do for those of you in Austin, Texas at Hembree Bell Law. We shoot it to you straight because we don't want you having the broken heart and the empty pocketbook that may occur if you file a custody modification when one is not warranted. If you want to change the primary residence of a child after divorce, and you want to do so moving beyond the geographic restriction that's likely in your court order in a Texas divorce, you're going to have a really, really steep mountain to climb. Any custody modification is difficult. You have to prove that it's worth it to the court to go undo prior agreements and prior orders to change something to protect the best interest of the kids. And we're really particular about where people live because Texas has this belief, it's even codified in the Texas Family Code, that children are better off with 2 involved parents in their lives. And just because one of the parents wants to move off because they found a new love interest or some new job, that's not going to really be a good enough reason, generally speaking, for a court to sever the relationship, the ongoing connection of this parent who still lives in the geographic restriction. So They're possible, but it's really some of the hardest stuff to do, to change a geographic restriction or move the primary residence of a child after entry of a divorce decree. When a Texas court is deciding whether a requested custody modification is in the best interest of the child, they're going to consider several factors, and they really can vary. But if you want to think about it in a practical way, what they're trying to figure out is, okay, if I do this thing that one party is requesting I do, will the child be safe? Will they thrive emotionally, psychologically, mentally, and in their education? They're really trying to figure out, is this kid going to be better off? They're not super interested in whether the parents will be better off. The child is the state's interest in this situation. So they might look to things like, okay, pretend your modification you're asking is for a relocation. If this child moves from Austin, Texas, up to, let's say, Seattle, Washington, is it going to have a negative impact on their relationship with the other parent who lives in Austin, Texas? What will the impact be on the child to leave behind the family members who live in Austin, or their school, or their cheer time? So, like, if you think about it, what the court's going to be considering is how whatever the requested modification is would affect the child. And if it's negatively, they're probably not going to do it. Even if it might be positive, the interest in stability likely outweighs it unless it's like super duper positive and the parent who they'd be leaving behind wasn't around that much or something, maybe in that situation. But you absolutely want to proceed with caution in these situations. It's really going to depend on which judge you have in which county, in which court, because they're just people. And they have their own perspectives on what's best for the children. And if you're deciding, you're like dead set on doing this, make sure you work with a lawyer who understands the court that you'll be in so they can give you their best possible advice of what's most likely to happen in your Texas custody or divorce case.